Can India give legal recognition to same-sex marriage? Is time ripe for such a social, cultural and legal change in India? Can this be achieved through courts and judiciary? And more importantly, why is the government opposing the recognition of same-sex marriage at the Supreme Court? Is there a real concern or is it driven merely by cultural dogmas? Hello and welcome to this edition of Let's Talk Law. I'm Anusha Soni. Today we talk about the issue of recognition of same-sex marriage in India and why the government is opposing such a move. Traditionally, marriage is understood as a union between a man and a woman. It's a sacred bond for life and beyond in Hindu beliefs and a pious contract in Muslims. In law, the Hindu Marriage Act and the Muslim customary law reflect the same. That's the legal position. The demand for recognition of same-sex marriage may be an argument rooted in equity and demanding greater civil rights for the community. But legally speaking, it's indeed an uphill task. The union government has opposed the recognition of same-sex marriage at the Supreme Court of India, quite expectedly. But that's not without its reasons. Let's go back in time a bit. In a rare, unprecedented move overturning its earlier judgment, the Supreme Court decriminalized homosexuality in 2018 and apologized to the LGBTQ community for the historical injustices. And it was only a matter of time that decriminalization will pave the way for other demands and greater civic rights. That's exactly what's happening right now. All civic rights in the personal sphere of life emanate from marriage or recognition of partnerships. Now, various petitions before the court demand that law should recognize same-sex marriages in the country. There is no final word on whether a culture as diverse as India, especially Hinduism, has space for recognition of same-sex marriage. The argument exists on both the sides. But legally speaking, there are various arguments that show that presently there is no fertile ground for Supreme Court to make these sweeping changes. An array of laws pillared on the heterosexual assumptions around marriage makes such recognition extremely challenging and difficult. Such recognition shall affect the laws around inheritance, adoption, domestic violence, sexual assault, divorce, maintenance, and even child custody and child rights. Let's break it down for you. Here are the 5 key reasons why it is difficult to recognize same-sex marriages in India presently. First, the scheme of uncodified personal laws. Marriage right now in India is governed by various personal laws. Marriage is governed for Hindus, Muslims, Sikhs, Christians, and Parsis and various other communities by their own religion-specific customs and law, which have a legal recognition. While some codes are evolved like the Hindu personal law, but there are other like the Muslim personal law, which are uncodified and governed by customary practices. Such a complex scheme of diversified personal laws make it extremely difficult for religion-specific laws to be gender-neutral. Religious leaders across lines have rejected the idea that marriage can be understood as a concept between same sex. Sweeping reform in personal laws is almost impossible in the present scheme of things. That takes us to another very crucial facet: the Uniform Civil Code. As we all know, presently there is no uniform civil code in the country. That means that multiple statutes, however patchy and piecemeal they exist, will need to be changed and amended. The Hindu Marriage Act, the Shariat Application Act, or the Christian Marriage Act, or perhaps even the special laws that deal with rights of tribals and indigenous people will demand an amendment. This is also a task that should be best left to the Parliament, since it will require deliberation of various sensitivities and critical issues. Third, the special protection granted under law to women, especially in matrimony. There are various laws that have been framed for the protection of women in marriages. For example, the laws around domestic violence and dowry. Will the recognition of same-sex marriage also mean that such laws need to be rationalized? Is it even possible to make them gender-neutral? What will be the safeguards in the same-sex marriages? Since the presumption of a man and a woman is gone, how will the partners be protected from violence within such marriages? Marital rape, for example, is not recognized. The issue clearly requires the intervention of the Parliament, arguably beyond the scope of the judiciary. That's what the union government has argued. The fourth, recognition of marriage as an institution is intrinsically linked to 2 crucial aspects. Raising children and property, both are going to be affected. In the case of same-sex couples, the demand would be to allow for adoption for such couples. It's one of the key things that has been said before the court. There is a serious doubt whether we have a social security system in place that is equipped to deal with such situations. Raising children in families is a function of society, and whether society is ready for such a big change is a key question. If adoption rights may be granted, what shall happen on an eventual separation? How will the custody issue be settled? The issue of custody is directly linked to the gender roles of a mother and a father. In same-sex marriages, such presumptions are irrelevant and gone. It's a radical social, cultural, and legal change that needs deliberation and wider consultation. Seeking recognition of marriage is not a fundamental right. The government argues that sexual lives of two individuals is not the business of the state. Sexual orientation is indeed part of right to life and liberty. But legal recognition to partnership, whether it should be given or not, is an intelligent distinction that the state is allowed to make. Centre says that such a decision is best left to the legislature and not judiciary. Now, the demand for recognition of partnership for same-sex couples is a step ahead in their fight for social and legal equity, without a doubt. But the objection of the union government is not merely premised on the vague cultural arguments. What's culturally sanctioned in a diverse country like India can never be conclusively agreed upon. In fact, the denial of rights historically does not mean that modern democracy shall continue the same discrimination. Cultural arguments against gay marriage is feeble and bound to fall. But indeed, on the legal footing, there is extensive reform, amendments, codification that needs to be done for any degree of recognition for such partnerships. Can the judiciary embark on such a task? The issue clearly needs a wider debate and discussion, whether it's in the Supreme Court or in the public sphere. Thanks for watching.